アジャイルガバナンスシンポジウム2026の2日目を始めたいと思います。本日はですね、京都までお越しくださりまして誠にありがとうございます。我々といたしましてもですね、このお寺を使ってですね、この歴史のあるお寺を使ってこのシンポジウムをやるというのは初めての試みでして、今日ちょっと運が悪く雨が降ってしまっているんですけれども、まだ少し桜も残っておりますし、かえって風情がある感じになって良いのかなというところもありますので、引き続きですね、議論に引き続きまして、面白い議論とですね、それから素晴らしいこの京都の黒谷の雰囲気を楽しんでいただければというふうに思っております。So thank you for coming the Agile Governance Symposium 2026, the day 2. So as you can see, so this is very traditional and the long history, the long historical the temple, and actually, so it is our first trial to use this the very privileged venue for our symposium. And unfortunately, so it starts rains, but still the cherry blossoms remains, and I hope it will remain after the symposium. But anyway, so you can still enjoy. You can still enjoy this very the special atmosphere as well as the cutting-edge discussions like today, like yesterday. So I hope, you can fully enjoy the discussion as well as the atmosphere. And please, actually, so as I mentioned, so there should be the simultaneous translation will be projected here today. But now, so finally we can solve the issues. But anyway, so let's start our discussions today. And で最初のパネルはですね、自動運転に関する日英の何ですかね、これまでの法の発展について、特に去年、一昨年ですね、英国では、2024年自動運転車法というものが、成立しまして、自動運転の車を走らせるための、包括的な、法律のフレームワークが、初めて、なんていうかはっきり、作られた。で、日本でもですね、一昨年、自動運転の、サブワーキンググループというものができまして、自動運転のための法制度を今回パネルに加わっていただいている落合先生とか私とかでなんかいろいろ議論しながら作ったという話があります。で実はですね、非常に面白いことにこの2つのですね法制度というのは非常に似た形でなんていうかなんていうんですかね、こう全体像が出来上がっていまして、今日はですねその日英のですねこう法制度のですねこう出来上がってくる背景なんかも含めて意見交換をしながら、これから先の自動運転システム、それから日本ではフィジカル AI がですねどういう形で社会的に使えるのかということが問題になっていますので、そういったところについて意見交換をできればと思っております。
Hi, good afternoon. So my name is Takafumi Ochiai. So as introduced Professor Inatani, I was a member of so 3 ministries, autonomous driving, regulatory expert meeting, and also I'm chairing startup and innovation working group of Regulatory Reform Council at Cabinet Office. Today, we'd like to compare the UK's so comprehensive approach and also Japanese incremental approach, and additionally, so business perspective from Parkshire Technology, one of the most prominent startup company in Japan. So today's key question is so how should safety standard and reliability be designed for autonomous vehicles? Or what are the so trade-offs between comprehensive legislation and incremental amendment? So we'd like to start from introduction of a speaker. At first, Alex.
Hello everyone, my name is Alex Glassbrook. I'm a barrister in London at Temple Garden Chambers. I wrote the first British legal textbook on automated and electric vehicle law, and I teach postgraduate engineers at Imperial College London on regulation.
Yeah, next, Kate.
Good afternoon, everyone. My name is Kei Takashi from Kyoto University. My academic field is criminal justice system, such as criminal law, criminology, and so on. In particular, I'm interested in the role that criminal liability should play in relation to actions involving new technologies, including automated driving. I very much forward to learning from the discussion and hearing different perspectives. Thank you.
Yeah. Yes, thank you. Yeah, Naoko-san.
Good afternoon, everyone. Thank you for having me today here. My name is Naoko Imaoka. I serve as the General Counsel at PwC Technology, a Tokyo-based AI company. And also, I used to work at a public sector and an autonomous driving company. Thank you.
Yeah. So today, we have three distinguished speakers at panel. And at first, we'd like to start from presentation from each speaker. So first speaker is Alex. Yeah. Oh, okay.
Okay, I think I've got some slide which are going to come up. While we're waiting for the slides, I'll just give, there we go, brilliant. Okay, so this is a talk about British automated vehicle legislation. It's a very detailed picture. I've got 10 minutes. So what I've done in the slides is I've set out all the detail. I gather the slides will be sent out to you afterwards. There are some notes in the PowerPoints which bring out the details. So if I sketch over anything at this stage, please do ask me questions later on, and the slides will come to everybody later. Okay, so the story in terms of the legislative approach in the UK starts in 2015 under the then coalition government. And it starts with the foundation of a dedicated policy unit, which was a policy unit jointly between the Department for Transport and what was then the Department for Business Enterprise and Industrial Skills. And it's known as CCAV, and that stands for the Centre for Connected and Autonomous Vehicles. And in February 2015, CCAV published its first report, The Pathway to Driverless Cars. That led to the first of two statutes. And the first statute was the Automated and Electric Vehicles Act 2018, and that dealt with civil liability and insurance. Just to step back, because there are some important differences between the British system and the Japanese system insofar as liability for road traffic accidents is concerned. The history goes back to the early 1900s, and this was when the tort of negligence was in the process of development, both in the United States and Great Britain and elsewhere. And in a series of cases, the higher courts in Great Britain had to decide the point, was liability for using a motor vehicle on a public road and causing injury to be dealt with strictly as a sort of no-fault matter, or was it to be dealt with on the basis of human fault and human actions? And in a string of cases, which included Wing and London General Omnibus Company, the courts decided that the motor accidents were to be dealt with on the basis of human fault. In other words, in the tort of negligence. And as we'll go on to see, that was a significant decision. That's then followed by two insurance measures. The Road Traffic Act 1930, which made it a criminal offence to use a motor vehicle on a road in Great Britain without third-party insurance. And then the Road Traffic Act 1934, which enacted the duty of insurers to satisfy any unpaid judgment in relation to a road traffic accident. You might be wondering why there were two statutes so close together. The answer is that after the Road Traffic Act 1930 was enacted, insurers started writing policies of third-party insurance, but they behaved commercially and packed those insurance policies with exclusion clauses, which made them almost impossible to rely upon as a third party who'd been injured. And that consequence, which should probably have been foreseen, led to the second act, the 1934 Act, which placed the duty on insurers to satisfy the judgment. So that's a potted history of road traffic liability law. So coming back to the Automated and Electric Vehicles Act 2018, here's the puzzle that a system which depended upon driver negligence presented for driverless cars. Where there's no human driver, how do you fit a new law into a system that relies upon human fault? And as Kay might discuss, and we might discuss later on, the Japanese approach is slightly different. Under the 1955 Act that deals with compensation for motor vehicle accidents in Japan, the legislation approaches it from the different starting point of use of a vehicle, subject to defences which can include reasonable care. But in Great Britain, we had to deal with the problem that if there's no human driver, we have to rewrite the system of fault. And that's what the 2018 Act does. The 2018 Act has one policy at its heart, and that's to make sure that the injured victim of a road traffic accident does not have to mount an expensive product liability action against the manufacturer of the automated system. And the reason for that is purely practical. Product liability actions are long, complex, and expensive. And if the system of road traffic compensation was to continue to operate effectively in Great Britain, a shortcut had to be provided around that expensive process for injured victims of driverless car accidents. And this was achieved in the 2018 Act by a number of devices that were new. The first one was a direct right of action by the victim against the motor insurer. That's a new device in British law. There was previously, under European law, a right on the part of a victim to issue proceedings against an insurer, but that's in respect of human fault. This is something different. This makes the motor insurer vicariously liable for the acts of the insured vehicle. So that's a significant shortcut. The Act also provides some more familiar remedies, albeit put into a new position. It provides for the defendant insurer the ability to plead contributory negligence. And that's contributory negligence on the part of the vehicle. There's some fairly complex wording to get around the fact that the vehicle is not a person, but that is a possibility under the Act, and that's also contributory negligence of the injured party. I'm going to come to this in a moment, but the injured party in a driverless vehicle case can include the person in charge of the vehicle, the person whom we might usually call the driver. They might have started the automated system when it was not safe to do so. The next thing that the 2018 Act does is it creates a secondary claim for the liable insurer. It allows them to go against a third party, and that third party might well be the manufacturer of the automated driving system. And then furthermore, the 2018 Act provides the insurer with some new available exclusion clauses. And those include liability for damage suffered by an insured person. This is where it's the insured person who's the user of the vehicle, where they have either altered the software of the vehicle or have failed to install safety critical updates. Under the 2018 Act, by contrast with the Road Traffic Act 1988, which deals with normal road insurance, those are the only available exclusions for the motor insurer. So that's the 2018 Act. After 2018, driverless vehicles did not appear as quickly as had been expected. And the brief history of this is that up to about 2018, certain manufacturers were representing that they had consumer-ready driverless vehicle systems ready to go. That did not quite happen. So in fact, there's been something of a pause since 2018. But in November of 2018, the government, through CCAV, instructed the Law Commission, which is the UK's independent law reviewing body, to advise on the safety issues and regulation of automated vehicles. And that started a consultation in November 2018, which was an extensive program. I see I have a time's up signal, so I'm going to whiz through this very, very briefly. The product of this consultation is the big act, the Automated Vehicles Act 2024, which, with indecent haste, is 100 sections, 7 parts, subject to guidance. New guidance came out on Tuesday. It sets out a number of highly detailed provisions, including a detailed self-driving test. I'll go through this in questions as time is running out. It also sets out a solution to the SAE Level 3 problem of mixed control of a vehicle, which is the introduction of new legal terms, which are user in charge of a vehicle for Level 3 and a no user in charge of the vehicle for Level 4. That provides for immunities. It also provides for a complex system of authorization, including continuous monitoring, and you might want to ask me about these in questions, specific offences, including the offence of marketing a vehicle as fully self-driving or automated when it does not meet that official description. Incidentally, that offence can be committed by tweet. I'm going to stop there because I've had the sign. In summary, that's the history. CCAV, 2018 Act, Law Commission consultation, big act in 2024. Thank you very much.
Yeah, thank you, Alex. And sorry for not allocating enough time. So Kei-san is the next speaker. So thank you for sharing UK's approach about accident claim from product liability into insurance scheme. Yeah, so this is very interesting, and we need to compare based on Kei's presentation walk through our Japanese approach. Yeah, please go ahead.
Hi, from my side, I would like to explain the outline of Japan's. Yes, from my side, I would like to explain the outline of Japan's legal framework for automated driving, while briefing following the process of legal amendments. First, as background, I would like to briefly explain the main categories of Japanese legal rules that are relevant to automated driving. Broadly speaking, the legal framework may be divided into 3 areas. The first is rules on the vehicle as a product. This area is mainly governed by the Road Transport Vehicle Act, or in Japanese, 道路運送車両法. The second is rules on road traffic. This area is governed by the Road Traffic Act, in Japanese, 道路交通法. The third is rules on passenger and freight transport service. This area is governed by such as the Road Transportation Act and the Motor Truck Transportation Business Act, in Japanese, 道路運送法 and 貨物自動車運送事業法. It is also important that these areas are dealt with by different authorities. The product side and the transport service side are mainly dealt with by MLIT, 国土交通省, while traffic rules are mainly dealt with by the National Police Agency. So, in Japan, automated driving is discussed across several legal fields and also across different competent authorities. This slide shows the development of legal amendments in time order. First, in 1929, with Level 3 in view, amendments were made in two main areas. Under the Road Transport Vehicle Act, the automated driving system, in Japanese, 自動運行装置, was added to the safety standards. Under the Road Traffic Act, the use of the automated driving system was included within driving. In addition, recording and creation of AGS operation data were required. Then, in 2022, with Level 4 in view, further amendments were made. Under the Road Transport Vehicle Act, the safety standards were revised for Level 4 vehicles. Under the Road Traffic Act, a permit system for specified automated driving, in Japanese, 特定自動運行, was established. And in the area transport service, a specified automated driving safety officer, in Japanese, 特定自動運行保安員, was introduced. Then, in May 2024, the report by the sub-working groups on social rule for automated vehicle in the area, so that Inatani-san said this report, yes, presented key issues from a more unified perspective. And based on that report, discussions are now continuing in the relevant authorities. Of these, today I will focus mainly on two areas. First, the further specification of AGS requirements in the safety standards. Second, the review of traffic rules in the light of automated vehicle deployment. I will also briefly touch on accident investigation and legal liability. In the following slide, I will explain these points in time order. I will start with product-related issues. In 2019, the automated driving system was added to the scope of the safety standards for type approval. More specifically, with the introduction of Level 3 in view, the automated driving system was brought within the safety standards as a system that substitutes for all the driver's function of perception, prediction, judgment, and operation. The UK introduced a new authorization process, while Japan incorporated automated vehicle into its existing type approval framework. So the next point is the further specification of safety standards for the automated driving system through guidelines. In the 2022 amendments with Level 4 in view, the safety standards were revised. The revised standards set conditions related to the ODD and also conditions on response when failure occurs. However, the safety standard itself still remains at a relatively general level. For example, the standard says that while the automated driving system is operating, it must not interfere with the safety of other traffic and must ensure the safety of vehicle occupants. So the basic legal standards exist, but it is still rather general in wording. At current stage, this general standard is being further specified through guidelines. The guidelines on safety assurance for automated vehicles were revised in September 2025. As methods for safety assessment, they recommend evaluation based on risk scenarios, including simulation testing, on-road testing, and the like, while also taking into account developments at WP29. The benchmark here is a competent and careful human driver. And another point is that the safety standard and related guidelines are expected to be updated over time. However, the concrete method for doing so is still under consideration. So, in short, Japan has already placed ADS within the safety standards, but the detailed content is now being developed further through guidelines. So next, I move to operator-related issues. In 2019 amendments, operation using the automated driving system was also included within driving. In other words, the law was amended so that driving using the automated driving system is also included within driving under Road Traffic Act, just as in the case of conventional human driving. This amendment was needed because the existing rules had been built around the concept of driving by a human driver. So, Japan revised the law to bring driving using the automated driving system within the existing concept of driving. Then, in the 2022 amendments, the system of specified automated driving was established. With level for automated driving in mind, a framework was introduced, under which operation managing the service are required to ensure compliance with Road Traffic Act rules that are difficult to comply with through the automated driving system alone. For example, providing aid to injured person in the event of accident and reporting the accident to the police. This framework assumes either remote monitoring or onboard supervision by a responsible person. A similar framework also applies to passenger and freight transport service, including the specified automated driving safety officer. So, this part is not only about the vehicle itself, it is also about how the operation is managed in practice. The next issue is the review of traffic rules in response to automated driving. Following the report by the sub-working group on social rules for automated vehicles in the era, traffic rules were reviewed to consider whether any existing rules should be reconsidered in light of automated vehicle deployment. However, the conclusion was that existing traffic rules should also be observed by automated vehicles. So, the view was expressed that no amendments should be made, merely because automated vehicles are being developed and introduced. This point is important. At least for now, the basic idea in Japan is not to change traffic rules just because the driver is replaced by an automated driving system. A related point was also made from the perspective of traffic rule and safety. It was stated that safety should be assessed on the premise that existing traffic rules are complied with by reference to a competent and careful human driver, which is used as a reference point in specifying the safety standards for the automated driving system. So, in the discussion of traffic rule as well, reference was made to the same benchmark used in specifying the vehicle safety standards. Next, I turn to accident investigation. Following the report by the sub-working group on social rules for automated vehicles in the AI era, MLIT is currently considering an accident investigation system aimed at preventing recurrence through fact-finding on accident causes, separate from legal liability. In other words, the idea is to investigate accidents, not mainly for blame or punishment, but for understanding cause and preventing similar accidents in the future. This role is expected to assign to the Japan Transport Safety Board, in Japanese, which has long investigated aviation, railway, and marine accidents. As for the expected scope, it includes three main categories. First, cases involving level 3 or higher automated driving. Second, case involving death or serious injury, or the risk of such outcomes. And third, traffic rule violation cases that often lead to death or serious injury. In addition, analysis based on incident level information is also being considered. So, the idea is not limited to very serious accidents alone, but may also include broader information collection and analysis. Finally, I will briefly touch on legal liability. The sub-working group on social rules for automated vehicles in the AI era also considered a corporate sanction scheme for accidents involving automated vehicles, drawing on deferred prosecution agreements, or DPA. However, because no consensus was reached among the members, the proposal was not adopted. Under the current framework, such accidents are addressed through existing civil liability, such as tort liability and product liability, and criminal liability, for example, negligence-based liability of natural persons. So, at present, Japan still responds to these accidents mainly through existing framework of civil and criminal liability, rather than through a new special sanction system for corporations. So, as I have explained, Japan has developed a legal framework for automated driving. At the same time, many issues are still under consideration, and I think we should continue to pay close attention to further developments. This is a brief outline of Japan's legal framework for automated driving from my side. Thank you very much.
Thank you, Kei. So you shown the Japanese discussion. So still working to specify the safety standard with international standardization discussions. So we are seeing competent and careful human driver benchmark. But this date, such as AI-driven systems like end-to-end model is becoming increased. So how can we still measure against such type of discussion? Naoko-san, please introduce your very practical perspective.
Today, I would like to talk about something that I believe will define the next decade of AI development. Not the technology itself, but the architecture of responsibility that must surround it. My title is Physical AI and the Architecture of Responsibility. When we say physical AI, we mean that acts in the real physical world, driving cars, operating robots, managing critical infrastructure. Unlike chatbots or software, the consequences of failure here are immediate and irreversible. A wrong prediction can mean a traffic accident, not just a bad movie suggestion. So the question becomes, how do we govern something this consequential? Before diving into the technical details, let me give you a map of where we are headed. This slide shows the logic from my argument. We start with the global AI policy landscape. Three major approaches from UK, Europe, and the United States and Japan. From there, we move to distinctive philosophy of agile governance, the title of this symposium, which I believe that holds important lessons for the world. Then we address the critical questions of AI safety and human judgment. These policies foundations lead us to two concepts that are central of PwC's vision, my company's vision, the co-evolution of people and AI, and what we call connective AI. That means reconnects the spaces between people and creates public value. Think of this not a linear argument, but a set of interlocking ideas. Each one reinforces the others. Next slide, please. Now let me ground this concrete example. Autonomous driving is undergoing a fundamental paradigm shift. The traditional approach is module: perception, prediction, planning, and control, each handled by a separate system with hand-coded rules. Depend on high-definition maps. It is transparent, but brittle. Every edge case requires a new rule. On the other hand, the new approach is end-to-end. A single neural network takes raw sensor input and directly produces a driving command. No HD maps needed. It learns from driving data, and crucially, it gets smarter the more it drives. There are also hybrid models that combine rule-based systems with end-to-end approaches. And these serve as a rational stepping stone in the course of technological evolution. However, the exponential pace of AI advancement is rapidly accelerating the shift toward fully end-to-end models. Also, I chose NVIDIA's Cosmos platform represent this frontier. World foundation models that unify word generation, vision reasoning, and action simulations across robots, vehicles, and machines. This is what we mean by physical AI, intelligence that is embodied, that acts in the real world. But here is the challenge. End-to-end models are black boxes. They cannot explain why they make a particular driving decision. Traditional verification methods, the kind we have relied on for decades in autonomous safety, simply break down. And that brings us to the governance discussion. So next slide, please. Why risk-based governance is inevitable? If traditional verification fails, what replaces it? The answer, I think, increasingly is risk-based governance. Let me walk you through three pillars. First, the safe case approach. In January 2026, the UNECE Working Group on Automated Driving, known as GRVA, adopted the safe case methodology. Rather than prescribing specific technical rules, it requires developers to construct an evidence-based agreement that their system is safe. This shifts the burden from compliance to demonstration. Second, risk classification. The EU AI Act classifies autonomous driving as high risk. It is not banned, but it is permitted under strict governance conditions. This is the essence of risk-based thinking, proportional regulation based on potential harm. Third, continuous improvement. The philosophy here is not zero risk. That is impossible with any technology. It is measured, managed, and continuously reduced risk. Your world data flows back in the system. the AI learns, the system evolves. This is risk management as ongoing practices, not a one-time occasion. Taken together, these three pillars represent a fundamental shift from prescription rules to adaptive governance, which, as you will see, aligns closely with Japan has been building. Please, next slide. Now, here is something that changed the entire framing. Autonomous driving is not merely a consumer product. It is increasingly understood as a social infrastructure, a public good. Consider the context. Japan faces an aging society where elderly citizens in rural areas are losing their mobility. Traffic accidents remains a persistent safety concern, and the robotics industry faces a severe driver shortage that threatens the supply chain. So, autonomous driving addresses all three of these challenges simultaneously. When we recognize this public nature, the framework responsibility must change accordingly. It cannot be about private liability rules. It must be about shared governance, an ecosystem where AI developers, automobile manufacturers, infrastructure providers, of course regulators and citizens, each bear distinct but interconnected responsibility. And even at level 4 autonomy, we do not see fully unmanned operation everywhere. Remote operators manage vehicle fleets and intervene in the edge cases. This is a practical, real-world model of human-AI collaboration, one that evolves together over time. It is, in fact, co-evolution in action, I think. So next slide, please. What physical AI is really asking of us? So, what is physical AI really asking of us? I argue it is asking us to make a leap from digital co-evolution to physical co-evolution. This fundamental question is not whether AI can drive. The question is whether society can build the architecture of trust to let in. Let me leave you with 3 principles. First, risk-based, not zero risk. We must pursue continuous improvement over the illusion of perfection. Second, public responsibility, not private liability. We need a shared governance ecosystem where every stakeholder can play the role. Third, connective, not isolated. We must bridge technology, regulations, and society, not treat them as a separate details. Building an architecture of responsibility is both an individual challenge and collective endeavor. At PwC, my company, we believe that the co-evolution of humans and AI, where human insight and machine intelligence sharpen each other in an ascending spiral, is not just a corporate vision, it is a necessary condition for responsible deployment of physical AI in our society. Thank you very much for your attention.
Yeah, thank you for presentation. It is a very important discussion to consider end-to-end system and also type of the black box discussion. And we move to a panel discussion. Yeah, so before starting panel, would like to hear from Alex about Autonomous Vehicle Act 2024 because you need to talk more on 2024. What is the most important concept in 2024, your new framework?
I think the essential difference between the 2024 Act and the Japanese approach is The 2024 Act puts a system of authorization and continuous monitoring and criminal offences aimed at companies into hard law, whereas the Japanese approach at the moment puts those regulations really into standards, which might loosely be described as soft law. The detail of the Automated Vehicles Act is another point, and just to develop that a little more, on Tuesday of this week, the British government published very detailed guidance in relation to the operation of the Automated Vehicles Act. And that guidance was aimed at applicants for the various licenses under the Act. That's aimed at operators such as Waymo, for example. It's aimed at local authorities whose consent is required under the Act for operation of automated passenger services within their areas. And also, guidance was aimed at emergency first responders. So police forces, for example, how they're supposed to act when they come across an automated vehicle. That guidance also went into issues of data and cybersecurity and indeed security of physical sites providing automated services. So it's highly detailed. As I say, the essential difference is the British approach puts these matters into hard law, and it's hard law that's enforceable both through civil sanctions and also ultimately through criminal offences. And the Act, I particularly want to link this into the discussion we had yesterday about corporate liability and corporate responsibility. The Act very clearly points offences at companies and at individual company officers who are responsible for example, the provision of information. So it's a detailed, hard piece of law.
Yeah, so that's a very important discussion. So our sub-working group also discussed about sanction system and also type of the corporation obligation from manufacturing company of autonomous vehicle. But it was not easy to implement immediately in Japan. But so it's one of the most important incentive system to make a good culture to cooperate public and private sector. I think. How do you see type of the making good culture for regulatory compliance in the UK Autonomous Vehicle Act?
Well, I'd be interested in input from particularly members of the panels yesterday in relation to this. I think my answer would be that, again, it's in the structure and content of the Act, because the Act has a rising scale of measures and penalties. It starts with measures, and these are measures which require companies to provide information on request by the regulating authority. And under the Act, the regulating authorities are various, but the particular office of statutory inspector is created. So the first obligation is to provide information. The second obligation, if information is not provided, comes into the enforcement area with civil sanctions. And if civil sanctions aren't complied with, then we get into criminal offences. So the Act has within itself a rising scale which starts from cooperation, to paraphrase, moves into civil sanctions, and finally moves into criminal measures. So it moves from, I suppose, what you could summarise as cooperation to full police powers, which incidentally include search warrants. And of course, the whole Act is built on information. So there are also detailed provisions about data sharing as well. So it's it's a very clear scheme, and it's the product of 4 years of very detailed consultation. Just as a general observation, the automotive industry compliance has always been built on standards. It has also been built on international law, as was referred to in relation to UNICE. But ultimately, vehicle regulation is down to the nation states. And I think what's distinct about the Great Britain approach is its prescription in terms of detail. And it's not universally draconian. It starts with cooperation and moves up.
Yeah. So, such a data sharing ecosystem or type of the legal system is very important, and we are also facing how to make such incentive system to share data because in some cases, especially Japanese big company, not to willing to share important information in type of the including regulatory sector. So how to implement such a good obligation system, because very simple obligation is not enough to make a good incentive system for company. We are thinking.
No, I mean on that point and just on data, the way that the Act deals with data is, as I say, it requires companies to provide information, but it provides protection of that information within its structure. So there are offences under the 2024 Act of sharing information outside the scope of the official role of the statutory inspector and others. But there's an exception to those offences, and the exception is that data can be shared with private companies, for example, who are involved in the manufacture of these vehicles. It can also be shared with insurers. And this exception has not yet been set out fully in its detail. It's going to be set out under regulations. It is the subject of considerable discussion under the insurance, in the insurance industry, because of course the insurers wish to have access to collision data. Now, what is collision data is partially defined by the guidance published this week. I won't go into the detail of that. It's a lot to do with timestamps and minimization of data. But the 2024 Act also sits alongside the British Data Protection Act, 2018, which is a creature of the General Data Protection Regulation from the EU. So again, that's another layer of hard law that the 2024 Act fits into. And just to make this general point, that is a crucial part of the design. It is hard law fitting within other areas of hard law. And I think this is perhaps the choice for national legislators. Do you wish, in relation to a radical technology such as AI, and when we're talking about driverless cars, we are talking about not just AI, but AI that has an immediate physical effect on the world around it, moving robots, essentially. If you're facing that sort of technology, do you wish to continue to deal with it on a soft law basis, on a standards basis, on a cultural basis? Or is this actually a matter for hard law and clear regulation? The UK approach is the latter. And I think it's a question for national legislators how they meet that choice.
Yeah. So this is so very important type of the intersection about so autonomous vehicle and physical AI systems. And so Naoko-san so discussed about so end-to-end system. And so how do you see so safety standards and so type of the so approval system should be designed for type of practical deployment?
Thank you. For emerging technologies such as autonomous driving and also physical AI, it is essential to manage the risk. Sanctions and obligations are also cost. So throughout the course of development, and particularly in the context of business deployment, we would like to measure the risks and the ability to plan for those risks in advance. It is a crucial step to develop the business, I think.
Yeah, so it's very crucial, and so we are very facing many types of the so regulatory barrier in Japan. So we are seeing so many of very previous regulations are working as type of the very old type of the hardware or system in Japan, because so we are very strongly so sentence to sentence interpretation. So we need to change so many type of the so actual regulations for implementation of artificial intelligence in many cases. So we changed so 10,000 articles in 2021 to 2024 in order to adapt to type of the so such a so safety standard or in the so private sector or some other software guidance in so very so old sectors. Yeah, so this is not easy discussion, but very important. And so we'd like to ask one more question to Naoko-san about so how do you think about type of liability systems and also insurance system? Yeah, so Alex explained so UK approach at first about such a product liability and also motor insurance. And so in Japan, we are also considering in sub-working group about change of the such insurance, compulsory insurance system. So please so share so Japanese discussion about such an insurance system and so autonomous vehicle.
Good question. The physical AI will impact on the physical world, so the hardware also needed because it affects all of the people. So clear and hard law is also essential. But for the development of the technology, the key point is ecosystem. Public, private, regulatories all shares ideas and making the steps to go forward. So I think the mixture of hardware and software like a guideline standardization is a point, and so the balance between them, I think.
Yeah. So such balance is yeah. So very type of the sensitive discussion in some cases, and also type of the consideration of not only such a regulatory environment, but such a liability system and so insurance system need to so type of protect in some cases developer in very coincidence type of the afterwards punishment in a civil or criminal case, but need to secure type of the victims from such a incident cases. Yeah. Would like to hear from Kei-san about change slide to next discussion. Kei-san, please compare UK's comprehensive legislation and Japanese incremental amendment. What are the trade-off of these examples?
Thank you. So my opinion, I do not think incremental amendment by itself is necessarily a serious disadvantage. If legal reform is carried out with a holistic perspective, with a shared understanding across institutions, and with room for reflexive updating, I think the disadvantage may be limited. That said, in Japan, one practical difficulty is the structure of government itself. Yeah. So different ministries and agencies are responsible for different part of the system, and that make it difficult to maintain the shared perspective in practice. But the working group report shows just horizontal approach. But my opinion, following that report, the discussion, each authorities, some member do not consider such perspective. So their view is very very old style, so analytic approach. Yeah, that is a very problem. So it is necessary to broad aspect. So a holistic is very good to live. Yeah.
Yeah. Yeah. So thank you for comment about Japanese situation about difficulty of making new framework among many ministries. I think this type of fragmentation is not only within Japan. Yeah. So many countries tackling this type of problem. I think and Alex explained type of the cyber security discussions and also data and also vehicle and type of artificial intelligence. I think there are many ministries or many officers in UK government. So how UK government collaborate in very cooperative way in autonomous vehicle discussion?
That's correct, but the clear approach has been to bring these decisions within one department, and the guidance published this week makes it clear that issues of authorization of automated driving systems are going to be dealt with by the Vehicle Certification Agency. And although it's correct to say that this is not the same thing as type approval of vehicles, it is inevitably an aspect of type approval of vehicles that have automated driving systems. And it's been designed to sit alongside the type approval system. So again, a matter which the British regulatory approach seeks to avoid is a proliferation of decisions by different civil servants. And again, one can see the good sense of that, because otherwise one is going to get probably very confused approaches. there are clearly challenges. There are ways in which the law is going to evolve. It's inevitable when regulating for new technology that part of the regulation is going to prove not fit for purpose in its current form and subject to amendment. And we've already seen that because there are aspects of the 2018 Act that are amended by the 2024 Act. But I think the parallel here is between the two Automated Vehicle Acts and the two Road Traffic Insurance Acts of the 1930s, because the system of road traffic insurance we have in the UK is essentially the system that was laid down by the 1934 Act, which was long before we joined the European Union, which was the other force that shaped motor insurance in the UK. But the system is essentially as laid down by the 1934 Act. I don't know, I know I'm speaking in a room of very eminent legal academics, so I don't hazard this as a general view shared by anybody else. But certainly my experience of research on deep legal problems is that when one is looking at a statute and a policy, that policy often takes a century or so to embed. And that's true of road traffic regulation. I think it's probably going to be true of what I'll broadly call robot regulation, because I think the Automated Vehicles Acts in the UK are one of the opening pieces of legislation in robot regulation.
Yeah, so thank you for sharing. And so we have so some minutes left. Let me open the floor to questions. No question. Okay. Yeah, so no time. Yeah, one question. Yeah.
As far as I understand, so the UK system, the new UK system, try to improve the quality and the safety of the automated vehicle system as a whole legal system. And to achieve that purpose, so as you mentioned, Alex, so the Act try to coordinate the relevant ministries and actually establish the new authority to coordinate each other. So I think from a viewpoint, so this iterative approach is a core principle of the new the legal framework for the automated vehicle in the UK. And I think the similar understanding is shared among the Japanese legal scholars. But as Kay mentioned, we can't get rid of the old past dependency. Yeah. So yeah, my question is, so if possible, so how we can get rid of this kind of past dependency? Because I think still the UK Act is new from the viewpoint of the UK people. And you mentioned, I think the hint is, you mentioned, so the some aspect is actually all, how to say, embedded in far before the UK tradition. So maybe we can take these points to combine or to make the basis for the new legislation is a point of technique maybe you mentioned. So yeah, but if you have any other strategies or ideas, yeah, I'm happy to have that. So thank you so much.
I think my only observation is at this stage is the 1955 Japanese law on road traffic accident compensation, I think probably starts from a better place than British law did. And that's simply because British law followed the development of negligence in the early 1900s in making road traffic negligence entirely about human fault rather than about any sort of strict liability. The 1955 Japanese Act starts from a different place. It starts from the position that the liability rests with the person, which can include a company, operating a vehicle on the road. Now, that is probably a better place to start regulating robots. Where you go from there is the next question. What I respectfully question is whether one can move from a statute, the 1955 Act, into mere guidance and soft law. It seems to me that that is not the obvious route. I think the obvious route is statutory.
Thank you so much.
So thank you for comment, Professor Inatani. So we conclude so today's panel, so session 5. So thank you for participating. This session.
Thank you.